Hi, Tony DeWitt here, Missouri appellate attorney and a guy who answers questions on YouTube. Today we're going to talk about appeals. Stay tuned. So somebody wants to know how many times an appellant is successful when they prosecute an appeal. And in order to do a full measure of justice, so to speak, on appeals, there are some things I need to explain. First of all, the person who files the appeal is called the appellant. The person on the other side whose judgment or action has been appealed is called the respondent. Sometimes they're called the appellee, but more and more they're being called the respondent. So those are the people who are involved, the appellant and the respondent, and that's the terms I'll use during the course of this video. Well, first of all, to answer the question, about 30% of the time, if the plaintiff appeals, the result is reversed. And about 35% of the time, if the defendant appeals, the result is reversed. Most of the time, the vast majority of appeals are denied. The reason why there are so few reversals is because there is a presumption in appellate courts that trial courts make the right decision. And that's sometimes a difficult presumption to overcome. Now let's talk about what it is that actually gets appealed. What gets appealed is trial court error. In other words, a mistake the judge makes in some way, form, or fashion. That is what gets appealed. You don't get to appeal the result if you don't like the outcome. If the plaintiff wins and you get stuck with $1 million judgment, you don't get to come back and say, well, I just don't like the judgment. You have to be able to show that the trial court made an error somewhere in the process in order to get a reversal. Now, it's not just the error that gets appealed. There are some things about that error that have to be done. First of all, the error has to be preserved. For example, if I'm conducting an examination of a witness and I ask them what another person said, and that conversation is not exempted from some exception of the hearsay rule, then it should be a hearsay objection. The other party should jump up and say, I object, Your Honor, it calls for hearsay. And if I can't defeat that hearsay objection, then that evidence shouldn't come in. But let's say the judge says, no, I want to hear this. And that evidence comes in and the jury hears it. That is a trial court error. But that's not the end of it. That the objection has preserved the error through the end of the trial. At the end of the trial, there is usually something called a motion for new trial, which is where the party who is aggrieved sets out all the things he thinks the judge did wrong. And that error has to be incorporated into that motion for new trial. That's how things get preserved for appellate review. Now, sometimes it's not the trial judge's error, but perhaps the legislature's error that gets appealed. For example, you may have a situation where a state legislature passes a cap on economic damages or some other thing that a particular person believes to be unconstitutional. That has to be raised at the earliest possible time. So, for example, if you're filing a lawsuit after that law goes into effect, one of the things you have to put in your original complaint or petition is that that statute is unconstitutional, and you have to set out the reasons why. Now, in most situations, just as there is a presumption that the trial court is right, the trial court has a presumption that the legislature acted appropriately. And 9 times out of 10, or probably closer to 99 times out of 100, the trial court is not going to declare the statute unconstitutional. They will leave that job to the appellate court if it gets done. But that error has to be incorporated also into the motion for new trial, and there have to be specific objections made if there is any evidence offered related to an unconstitutional statute. Here's the other thing. Errors can be waived. Errors can be waived quite simply by either not raising them or not preserving them in the record. For example, lots of things happen at a trial that do not go into the record. For example, before somebody might be examined as a witness, the lawyers might meet up at the judge's podium and say, the judge might say, I'm not going to let this guy get into subjects A, B, and C. And if you object to that, you have to put that objection on the record. Now, usually you do that outside the presence of the jury, but you have to put that objection on the record, because if it doesn't show up in the trial transcript, you didn't preserve the error, and that's on you as the lawyer. So, errors can be waived by not getting them into the record. They can be waived by failure to assert in the motion for new trial. They can be waived by not being presented in the first appeal. Sometimes there are cases that are appealed multiple times, and if you don't raise an error at the earliest possible time, well, then you've probably waived it. So what is with all of this preservation and getting things into the record? It's to make sure that when the record gets to the trial court, from the trial court to the appellate court, that the appellate court has a good basis to rule. It has all of the facts that it needs to make a determination as to whether the trial court made an error. So that's what the purpose of it is. Now, after the motion for new trial is denied, the next thing that happens is the appellant files a notice of appeal. And that notice of appeal gets sent to the appellate court, and the next thing that happens is the record gets created for the appellate court. The appellant will go back through all of the pleadings, and he will pick out the pleadings that are relevant, because a lot of things that are filed at the trial court level don't wind up being relevant on the issues on appeal, and you don't want to make an appellate court go through a 500-page record when they can go through a 100-page record. The appellate record gets made, the trial transcript gets transcribed and put into written format and sent up to the appellate court, and now it's time for the appellant's brief. At the appellant's brief, one of the very first things that has to be decided is what is the standard of review. In other words, at what level is the appellate court looking at the trial court's decisions? For example, if you have a question of law, does a statute apply? Does a statute not apply? Is a insurance contract valid or invalid? These are questions of law, and those are reviewed by the trial court under what's called a Denovo standard of review. Basically, what that means is the trial court doesn't get any deference whatsoever. If it makes the wrong call on the law, it gets reversed. So that's the best and most useful standard of review for an appellant. The next standard of review is called abuse of discretion. And this usually applies for evidentiary errors. In other words, is that really a hearsay exception? The trial court's decision on that is discretionary. In other words, the appellate court is only going to reverse, in most cases, if reasonable minds couldn't disagree about whether it was hearsay or not. That's why abuse of discretion is a terrible standard to use in appellate cases, because courts are very unlikely to reverse on it. And then finally, there's something called plain error. You'll see this a lot in criminal cases, where a trial attorney for a defendant does not object or does not take action to stop something at the trial court that is deemed to be a violation of somebody's constitutional rights or other right to a fair trial. If they don't object and they don't preserve the error and it doesn't go into the appellate record, then the only way that it can be appealed is through plain error. In other words, somebody has to show that this is such a mistake that it absolutely defeated this person's right to a fair trial. That's a very high standard to hit, and it is very, very rarely employed to reverse a case. So after the appellant files their brief, the respondent gets to file a brief in response and basically tell the court why the appeal should not be granted. After the respondent files their brief, then the appellant gets to file a reply brief, basically saying the respondent is wrong and here's why. The appellant gets 2 shots at the record for one reason, and that's because he has the burden of convincing the appellate court that he's right. So after the case is fully briefed and submitted to the appellate court, the next thing that happens is oral argument. In most cases, although it happens less now because of the pandemic, in most cases you get an opportunity to make your case in front of the appellate court. But you're not going to get a very long time. In Missouri, for example, the appellant will usually get 10 minutes to make their claim. The respondent gets 13 minutes to rebut that claim, and then the appellant gets 3 minutes in rebuttal to more or less go back and say why the respondent is wrong. So that's how that works, and that oral argument is not what you might think. It isn't somebody getting up and giving a long speech without interruption. In fact, judges quite often interrupt appellants during the course, and respondents too, during the course of their oral argument. Now, the other thing that's interesting about appellate law is that courts only decide the issue that needs to be decided. You may recall recently that the Supreme Court took up a gun case. And then immediately after the Supreme Court took up the gun case, the city of New York changed its rules so that the gun case was moot. It was no longer necessary to be decided. Now, the Supreme Court could have decided it under a doctrine called capable of repetition yet avoiding review, but it chose not to. And that's because it decides only those issues that are most important and that are necessary for it to decide. So what happens after the appeal is denied? Well, usually there's a process for the appellant to call any errors that the appellate court may have made in interpreting the record to its attention through what's called a motion for rehearing or a motion for rehearing en banc. Either of those two motions can direct the appellate court to re-examine its record and perhaps reach a different conclusion. That works in about 0.5% of the time. Most of the time, the appellate courts are pretty sure they got the right answer, and they don't do anything about it. If it is an appellate court at an intermediate level, for example, in Missouri we have trial courts, we have intermediate courts of appeal, and then we have the Supreme Court. It is possible for the appellant to move to transfer the case from the intermediate court up to the state Supreme Court. The state Supreme Court, of course, does not have to take that case. And then, finally, if there is a constitutional question, meaning a United States constitutional question, in the case, then the appellant can file what's called a petition for a writ of certiorari. Certiorari is Latin that basically means send up the record. And you're asking the Supreme Court to ask the state court to send it the record so that it can decide these cases. According to statistics published online, a writ of certiorari is only granted in about 2.8% of the cases that are appealed to the United States Supreme Court. So there you have it. That's the answer on appeals. I hope that has been interesting or helpful. If it has, I'd appreciate it if you'd punch the like button there, and if you found this to be helpful, please subscribe and push the like button and leave a comment down below, because the comment helps feed the YouTube algorithm, and it makes it more likely that I will continue to publish these little vignettes as we go forward. Again, thank you for watching. Have a terrific day.